Great. Hello, everyone. Thanks for taking the time to join us. We're just going to wait a few minutes for people to be released from, I assume there's a holding room somewhere in the ether. And so we'll just give people a chance to join us. Ian, how does it feel when you're past the term? You've done this for several terms now. What's it like to be done for a little while?
This year is unusually exhausting because it was such a busy term.
Mm-hmm.
One thing I'll probably say, during the event is like the court's docket keeps on shrinking. They only decided 59 cases this year, but like the number of political cases is growing and growing and growing. It was like 20 something cases, and like it's harder to cover the political cases, not just because like the stakes are really high and I care about them emotionally, but because those are the cases where like I'm least able to analyze them like a lawyer.
Right.
I have to do, like try to figure out what happened in Trump v. United States, like relying on the tools that I was taught in law school is not, that's not going to help.
Yeah, no, I understand that. Well, I have a good question for you about that. I do this podcast every once in a while, Come Forward Justice, and I have my own theories about what's actually at play, and I'll be curious to get your input on that. But that's good. So, but for most Supreme Court reporters, is it the case that it's the end of term and then you take a month off, 2 months off? I mean, because you're not sort of re-engaged until, I assume, after Labor Day, when now you're looking at unless something happens over the summer with an emergency.
Yeah, I mean, I never take a month off. I'm going to take a week off, but normally I spend my summer, writing like the big think pieces about the court that I didn't have the time to do while I was just reacting to the news, and like jumping on other, issues that where like law and politics touch. It's a presidential election year, so like, I'll do some coverage of like, what would Trump mean for the courts? What would Biden mean for the courts? Trump will probably release his list of justices, of potential justices at some point. So I will cover that list and what it tells us about what the courts could look like in a few years. There's always something to do that's at least adjacent to my core beat. But like the summer normally means I have time to spend, several days on a piece rather than, frantically trying to get something up 80 minutes after the Supreme Court hands down a 200-page opinion.
Right. Yeah, I've always been incredibly amazed at how quickly you all process the information, because even when we're releasing very, very short statements, I sort of work with the team. And I was like, we can't just read the syllabus. We have to sort of make our way through this. And I know how to sort of cut through some of the procedural stuff, but now that's become increasingly important. So you're trying to attend to it.
Yeah.
Well, in any case, let's get started. It looks like folks have, we've got enough people here. So good afternoon. Thank you for joining today's Holding Court event. For those who've been here before, you'll know me, but for those who haven't, I'm Rakim Brooks, president of the Alliance for Justice, and we're an association of more than 150 organizations who are committed to building power, transforming courts, and securing justice for all. Our conversation today is part of our ongoing Holding Court series, and it features leading activists, scholars, and attorneys, journalists as well, to discuss our current political and social justice issues. And I'm very, very honored to have Ian Millhiser here with me today to discuss the 2023-2024 Supreme Court term, which for those of you who are just now joining, we were talking about earlier, was quite a doozy. And with a lot of things I think we expected, but maybe some things we didn't expect. And that'll be worth inquiring with Ian about, since he's been chronicling the court for some time. Let me just give him a quick introduction, and then I want to jump in. So Ian is a senior correspondent at Vox and a legal expert on the Supreme Court and the Constitution. He's written 2 books, which I would highly recommend to you: Injustices, the Supreme Court's history of comforting the comfortable and afflicting the afflicted, and The Agenda, which is a short little primer, if you are unfamiliar with what this court is doing at the moment, on how Republican Supreme Court is reshaping America, both of which offer informed, nuanced view on the state of our nation's highest court, the past and the present. So Ian, thank you for joining us.
It's great to be here. Thanks so much.
Yeah. Well, let's jump right in. You wrote a piece just yesterday or 2 days ago, I believe. Yeah, landed on the 8th, sort of summarizing exactly what's been going on with this court over this term and the myriad ways in which you say they're not very good at doing their job.
Yeah.
So just summarize at a high level for our audience what that piece was trying to achieve in the aftermath of this term.
Yeah. So, like, I think there's two critiques you can make of the Supreme Court. One is like, I don't like their decisions because I lean left and they lurch right. And like, certainly I can make that argument as well. But like, just as a matter of judicial craft, these guys are just awful at their jobs. And let me give a couple examples. One is the Rahimi case. So Rahimi was the follow-up to a case from 2 years ago called Bruin, which essentially eradicated all pre-existing Second Amendment law.
Yeah, so these are gun cases, right?
Yeah. Told the lower courts that like the way that they have to do that they have to handle every Second Amendment case is like, go look at the laws that existed. They weren't even clear about which date, but probably 1789 or so. And like, see if there were similar laws to the one that is being challenged back then. And then if they weren't, there's an extraordinarily strong presumption that should be struck down. And the Fifth Circuit, and normally I have lots of terrible things to say about the Fifth Circuit, but I think if you take Bruin seriously, what they said in Rahimi was correct. There's a federal law which says that if you are under a domestic violence restraining order, so a court has determined that you are a violent threat to your spouse, your romantic partner, your partner's child, then you are not allowed to own a firearm. I think any sensible human being would think that's a good law. But the Fifth Circuit struck it down because there wasn't a similar law in like 1789. And if you take Bruin seriously, that was the right result.
Right.
And so this comes up to the Supreme Court. 8 justices realized, oh yeah, this is untenable. It's not just that this guy had a restraining order. He had committed 6 shooting crimes, like not just gun crimes, but like crimes where he actually discharged a firearm. And the Fifth Circuit had said that guy has a right to own a gun. So 8 justices realized that was terrible. But rather than overruling Bruin or clarifying Bruin or providing any edification as to what Bruin means, they just said, well, like, with still the same rule, look at what the laws were in the past and see if there's one that's kind of similar. But now the test is only has to be kind of similar and not exactly similar. Like, they didn't provide any guidance. And, I thought Justice Jackson's concurring opinion was extraordinary, where she had this footnote where she quoted from a dozen different lower court decisions, some of them written by like Trump appointees, saying, look, we don't know what to do with Bruin. We don't have these research skills. We're not historians. We don't know how this standard works. Because this involves any gun crime, it now means that every public defender in the country, every time they have a client who is arrested for a crime involving a gun, they make a Bruin argument. So you're talking about thousands and thousands and thousands of cases that the courts don't know the answer to. Please, Supreme Court, fix this. And the Supreme Court provided no clarity at all. The Rahimi opinion's 18 pages long. It vaguely restates the Bruin test with like some language indicating like do it less strictly than the Fifth Circuit did. It babbles about the history of gun laws for a while, and then you're done with no idea what's going on. And so that's one example of like this court just not knowing how to do its job competently. I've been talking for a while, but I'll give one other example. And that's the Trump immunity case, Trump v. U.S. When I first read that opinion, I thought it was a blueprint for dictatorship. It is very explicit that the president of the United States cannot be prosecuted if he orders the Justice Department to round up all of his enemies and throw them in a detention camp. It says like any communication between the president and the Justice Department. The language that it uses, conclusive and preclusive. Nothing can be done with the president over that. It's pretty clear. It's a little more uncertain, but pretty clear that the president could probably send the military to kill his enemies. So I read this thing and I thought, my God, like, are these guys trying to set us up for a dictatorship if there's, in a future presidency? But like literally like 5 minutes before they handed down Trump v. US, they handed down this other case called Moody v. Net Choice. If you're not familiar with the Net Choice cases, Florida and Texas passed laws that essentially tried to seize control of content moderation on at the major social media outlets. And 6 justices, including 3 that joined the Trump opinion, reached the entirely reasonable conclusion that no, the government is not allowed to seize control of editorial decisions of the media's editorial decisions. It's the most banal First Amendment holding you could possibly imagine. I mean, obviously, the government is not allowed to tell the media what it can and cannot print. And when I read those 2 in conjunction, I just didn't understand what was going on. Like, if they want a dictatorship, why wouldn't they give the government the power to seize control of the media? But if they don't want a dictatorship, why did they hand down that Trump opinion? It just makes me wonder if they fully understood the implications of what they were saying when they said that the president can order the Justice Department to arrest anyone at all and nothing can be done about it.
So this is where I wanted to test my theory on you about what I think is happening. And the way I described it on my podcast was that the dog has caught the car. So what I said to a lot of friends, going back to Trump destroying various presidential records, was that this court are a group of descendants of the people who were Nixon era Republican lawyers who have been obsessed with the idea that they feel we somehow hemmed in the president with the various Watergate reforms and ethics reforms. And so what I said about about that case was basically, don't be surprised if the Supreme Court says Congress cannot tell the president that the president can't crumble up the piece of paper that he just wrote on and throw it in the trash can and enforce some sort of Presidential Records Act. Just watch. Right. So when I saw the Trump v. US case, and they came out with their decision being that it was written by John Roberts, who was, of course, the disciple of William Rehnquist, who was, of course, in the Nixon Justice Department and an acolyte, and then Samuel Alito, little Scalia, and so forth. I just thought this is them achieving what they've always wanted to achieve, which is their form of the unitary executive, what we on the left sometimes call the imperial presidency. So I wasn't at all surprised by the decision, but to your point, it's an entirely different context. And I'm not sure that they appreciate fully. I don't know how they couldn't, actually, given everything that's going on in the world. These aren't dumb people, but they don't seem to fully appreciate how the legal doctrines they've been fighting for decades are now have very different implications for the president. I've got you, so I figured I wanted to get your reaction. Like, I've not seen any of the coverage mention US v. Nixon, that this is actually what they're trying to undo. They just have chosen a totally terrible time to work out this particular fetish of theirs.
Yeah. No, I mean, I think that a lot of these guys, and I mean, I don't want to talk about the 6 justices in the majority in Trump as if they are a monolith. Like, Sam Alito, I think, is just a hack. Sam Alito will do whatever the conservative wing of the Republican Party wants him to do. But there's more going on, I think, in, say, Amy Coney Barrett's head than there is going on in Samuel Alito's head. But what I think is going on in Amy Coney Barrett's head is that she lives in this world of theory. She was a legal academic. There are all of these ideas that people came up with in a context where they were just fun ideas to play with. And then, here is, well, I guess I'll just offer a reason why I am cautious about a world where lawyers and particularly litigators wield the kind of power that they do because of the Supreme Court that we have. And that, I attend I try to cover the Federalist Society's conference every year. I've covered the Federalist Society for more than a decade. And, the joke that everyone tells about the Federalist Society is they like to call themselves a debate society. And of course, that, what they're doing is that they're trying to advance a right-wing agenda. But I actually think that the debate society aspect of the Federalist Society is legit. What they do is they get together and they hash out amongst themselves, here are the things that we want, here are the disagreements that we have. They try to reach consensus. And then once they reach consensus, they all march in lockstep. And so they might reach consensus on an idea like the unitary executive. And once they have reached that consensus, they stop. Not only do they, stop questioning, well, wait, is this really a good idea? Is this really a good idea in this context? But I think that their lawyer brain kicks in. Like the way that lawyers are trained to operate, I'll quote the rules of professional conduct: zealous advocacy. Whatever the goal is that our client wants, we have to, push. If my client wants to save $10 and the only way to save my client $10 is to kill 1 million people, then I've got to be in court arguing for 1 million people to be killed on the theory that there will be a lawyer on the other side who will make the opposite argument. I think the problem that has emerged is that, the Federalist Society lawyers now, they are taking this ethic of zealous advocacy and they are applying it in a context where we essentially don't have a functioning adversarial process anymore, because Brett Kavanaugh isn't saying, what are the arguments on either side? Amy Coney Barrett isn't weighing the arguments. They have already committed to an approach, and now they are zealously advocating for it. And when you get into that mindset, I mean, I understand why that's the appropriate mindset when you are representing a client. But when you are a judge or when you are deciding issues that impact the entire country and you don't have the countervailing force of the other lawyer on the other side saying, hey, this isn't worth $10, then it can lead you to do some pretty mad things.
In that context, how are the liberals doing? I mean, we know that Justice Sotomayor is at her wit's end based on some of her public comments, but in terms of the opinions that they're writing, you mentioned Justice Jackson's dissent in the Rahimi case earlier and the strength of it, really, and just taking the test on its own terms and saying, we are judges, we are lawyers, we're trying to apply this thing. But on the more political cases, not that that's not political, but on some of the other cases, how are they doing? And is Justice Sotomayor sort of dutifully leading the left wing?
So actually, let me talk first about the two other liberal justices, because I see something in Kagan and Jackson that I think is very revealing. So Kagan has historically been the person who tries to cut deals. So Kagan, I mean, she gave an interview several years ago, I think right after Justice Kennedy retired, with Dahlia Lithwick, and she told Dahlia, look, my job is to make cases as small as that I can make them. My job is to find some sort of procedural way to get rid of this, to find some way. I mean, think about cases like Masterpiece Cake Shop, which essentially held this one guy gets a religious exception that lets him get away with violating an anti-discrimination law, but we're not deciding anything else. That was what Kagan saw as her role. And so, if you are a liberal intellectual looking for something to root for, reading Kagan's opinions could often be very frustrating, because she didn't see her role as I'm the one who's going to go out there and talk about the world as it should be. She saw her role as, how can I work with John to make sure that no one gets hurt that doesn't need to get hurt by this decision? And, I'm glad she did that. In the last two terms, her opinions have been indistinguishable from Sotomayor's or Jackson's. She has been hitting just as hard. She's been mocking her colleagues. She's what her dissents has told me. I mean, I think they're very good, very persuasive dissents. But what her dissents has told me is she doesn't think she can work with these guys anymore. I mean, there have been some concurring opinions where she's gotten, in the CFPB case, for example, she got Kavanaugh and Barrett to sign on to a concurring opinion saying, hey, there should be limits to how much we blow up something that's been going on for hundreds of years just because someone writes a law review article saying that it doesn't comport with originalism. So sometimes she is able to reach across the aisle and get things done, but she's doing it less and less. And I think that's a worrying sign because I think Justice Kagan is very smart. I think that she makes very intelligent choices about how to form those kinds of alliances. And when she starts saying, I can't work with these people, I mean, if she can't do it, I don't know who can. Jackson has really impressed me as a new justice. And what I think makes Jackson interesting, after her first term, in one of her first oral arguments, she gave a very compelling originalist defense of affirmative action. And I think, there were a lot of scholars who start to, is she a liberal originalist? Is she trying to come up with some way to, reconcile originalism with liberalism? I don't think that was entirely right. I think what's going on with Jackson is she is the first justice to join the court who has basically spent her entire career as a litigator and then as a lower court judge in a world where the bad guys had already won. In the world where she had to be able to make arguments on their terms. And so she got really good at it. I mean, I think she's a better originalist than Gorsuch or Thomas or these. Justice Jackson can make a stunningly compelling originalist argument for her position. And the reason why isn't because she believes that originalism is the only legitimate way to interpret the Constitution. It's because she understands the playing field that she's been operating on. And I think she sees her role very unlike the way that I described Kagan's role. Whereas Kagan is trying to form those alliances, I think that Jackson, and also Sotomayor, but I call out Jackson because I think it's very interesting the way that she sort of incorporates the methodologies and arguments of her opponents when she does it. She sees her role as not just writing about the way that things should be, but calling the other side out on the carpet. There's a lot of opinions where Sotomayor or decisions where Sotomayor or Kagan wrote a dissenting opinion, and then Jackson also writes a separate dissent, which is, I just want to bring this one thing up. And so I mean, I think that they're the liberal justices are doing a good job of thinking about not just what is my role, but what is a role I can fill that someone else isn't already filling. You don't want three of them to all be doing what Kagan is doing, but you want one of them to be doing what Kagan is doing. And you don't want all three of them to essentially be, liberal Justice Thomases who just shoot for the moon in at every case. But it's, to the extent that Jackson is trying to be a liberal Justice Thomas, it's nice having one of them around.
Yeah, for sure.
Yeah.
I was going to ask you to put this term in the context of, let's call it the Trump Maga court. That is, he appointed 3 justices. The court is now firmly to the right, anchored there somewhere between, I don't know, Neil Gorsuch and Amy Coney Barrett, right. And John Roberts is the median vote. But in 3 terms, what we've seen is that they've overruled Roe, a 40-year-old project of theirs, 40-plus-year-old project of theirs, overruled affirmative action, a project with a similar longevity in their mind. This time, they've now taken on the administrative state, and as we were talking about earlier, the diminished view of the presidency that they see in their ideology. You could either ask you what's next or how you think about how much has changed. You put this in your article about law professors needing to fundamentally change their textbooks and their approach to law. I mean, I don't think people fully appreciate how radically the law has changed in a very short period of time. You've had conservative courts going back to Berger, but things still moved at a certain pace where, yeah, bad things were happening, but it wasn't that they ripped the Band-Aids off all at once. In this case, it's like they've ripped the Band-Aids off, the gauze, they've dug into the wound, and they're doing something
Right.
entirely different. So how has it felt covering that to you? And do you think the public is fully appreciating what's happening in our law?
Yeah. So my dog really doesn't appreciate what's happening in the law right now. No, he's not a fan. I think that a lot of these guys came in with a checklist. And the checklist, I mean, on some level, you have to admire the political organizing project that is the Federalist Society and the conservative legal movement. They have thousands of professional intellectuals. And like they all got them marching in the same direction on like, we all want to get rid of Roe. We all want to get rid of affirmative action. We all want to, disempower the administrative state. And like, if you've been following the court seriously for the last 10 years, you know what's on that checklist. And, the piece that I wrote at the end of last term was about how like the power of holding grudges. What the conservative legal movement, what the Federalist Society did, what they did within the Republican Party that was really effective, is that they organized and like they reached a consensus amongst themselves what are the items that any judge appointed by a Republican president has to be willing to do, have to be willing to overrule Roe, have to be willing to get rid of affirmative action. I think the open question is once they are done with what items on that checklist, then what? And the answer, I think back to one of my early career experiences is I was very involved in the litigation in NFIB v. Sebelius, the first lawsuit attacking the Affordable Care Act. And if you remember back to like 2012 when that was going on, what happened was there was this lawsuit. It had this really silly legal theory that there's an activity and activity distinction in the Commerce Clause that no one had ever heard of before, and that appears to be made up solely for the purpose of taking out this one statute and doing nothing else. And no one took it seriously. Famously, like there were law schools that wanted to hold debates on like this legal theory, and at least early on, they couldn't find someone to debate that the Affordable Care Act is unconstitutional because it's just a very silly theory that has no support, as Judge Lawrence Silberman, not a liberal, said in his opinion, has no basis in constitutional text or Supreme Court precedent. And all of us were wrong. And the best article I've read about why we were wrong is a piece by Jack Balkin, which argued essentially that when political media and legal elites line up behind a particular legal theory, that alone is sufficient to take it, the language he uses, from being off the wall to on the wall. And it's sufficient to do more than that. I mean, it's sufficient to get all of the justices who belong to the same political party as whoever is behind this legal theory to potentially rally behind this theory. And so if you want to know what's next after they're done with their checklist that has Roe and affirmative action and all the other things that we already knew was coming on it, I think you're better off watching Fox News, or for that matter, watching panels at the Federalist Society, because like what legal elites say matter a lot as well. You're better off watching, are there U.S. senators who are touting this legal theory, then you are using the traditional tools that we all learned in law school, reading precedents and reading text and trying to figure out what the text says. Because, I mean, obviously text doesn't mean anything in this court. But like, and so how does that play out? You have some cases this term. So you have the CFPB case this term, for example, where the Fifth Circuit, in an opinion that like basically made up a limit on congressional appropriations that like not only has no judge ever like thought of this idea before, but as far as I could tell, not very many humans have ever thought of this idea before. Like the Fifth Circuit cited one law review article that was published in 1988 that made a sort of adjacent argument to the one that they then relied on to strike down the CFPB. But like, this is an argument that like just came from nowhere. I mean, even, as much so as the activity argument attacking Obamacare. But like, there wasn't like, it's not, unlike the NFIB case, you didn't have U.S. senators going on TV talking about how like the CFPB needs to be struck down. The Federalist Society, I'm sure they did panels on it, but it wasn't like a huge focus of their programming that like this appropriations theory needs to be taken seriously. And so what we got was a 7-2 opinion by Justice Thomas, saying that, no, this thing that the Fifth Circuit made up in 2022 is not, in fact, the law. And good. When something just emerges from nowhere and no one breathes any life into it, it turns out it doesn't go anywhere, or at least it doesn't go anywhere in the Supreme Court.
Well, you're raising I'm sorry, go ahead.
Well, the case I will use to contrast CFPB is the Trump immunity case. Because, there's no presidential immunity clause either. I mean, one thing that like several news outlets have pointed out is like several of the justices who joined the Trump opinion said in their confirmation hearing, of course the president can be prosecuted. He's not above the law. So like, this was a theory that was no less ridiculous than the theory in CFPB. But the difference is that the Federalist Society, Republican political elites really did care about, Fox News really did care about whether or not Trump could do whatever he wanted to. And I think that more than like, reading precedents or like reading old dissents to see if they have enough votes that they might someday become a majority opinion. Fox News is going to tell you a whole lot more about what the Supreme Court's going to do in the future than anything that anyone on the Fifth Circuit says.
Well, that's as breathtaking as it is frightening. But one of the things you're drawing out is a relationship between, let's call it the legal intelligentsia, the conservative movement, and the conservative public.
Yeah.
And obviously, as of late, one of the central topics of concern on the left has been Project 2025, a new child of the Heritage Foundation, which again was very instrumental in shaping Reagan-era policies. As you think about what might come next on the checklist, or the relationship between the checklist and the social agenda that's being pushed external to the court, where does Project 2025 figure, if at all? How are you all in kind of the left-leaning media covering the court thinking about helping folks to understand that these two projects might very well be more intertwined than they initially appear?
Yeah, so I guess I'll start off by saying like the book that Project 2025 released that summarizes all of their ideas is like 870 pages long or something. So there's a lot of stuff in there. And I mean, I will confess I haven't gone line by line through the 870-page book to figure out how much of it is making it into Supreme Court arguments. There is some stuff that I think thus far a majority of the justices have not shown any interest in. So, there was the Meafy per Stone case. Project 2025 wants to ban Meafy per Stone. They have several different legal theories for why they can ban it. They also floated this idea that, we talked about some more, that a law signed by Ulysses S. Grant called the Comstock Act bans all abortion, and like only Alito has really showed any interest in this Comstock theory. So like there's some stuff in there that at least thus far the justices haven't latched on to. But a huge thrust of Project 2025 is this project of dismantling the administrative state's ability to enact regulations that certain people don't like. They have obviously they have no problem with, say, like putting a political appointee in the FDA who will then pull Meafy per Stone from the market. So like they're not against agencies exercising power altogether, but like they want to roll back the agency's ability to regulate things like power plants, to emissions, the workplace, The healthcare system, there's a case making its way up. It was just decided by the Fifth Circuit that wants to, the Affordable Care Act has a provision saying that insurers have to cover, like your health insurer has to cover certain vaccinations and certain preventative treatments. And there are various bodies within HHS that determine what's on that list of mandatory procedures that your insurance has to cover. And it's a lawsuit basically seeking to eliminate HHS's ability to create that list or to enforce the list of things that it already has. So, if if your insurer doesn't want to cover your COVID vaccine, they can give you the middle finger and say they're not going to cover your COVID vaccine if this lawsuit prevails. And like that anti-administrative state project, that's one of the core projects of Project 2025 is already underway. And it's underway to an extent that I think has surprised me because for a while, for the first part of the Biden administration, the court invented this thing called the major questions doctrine. Now, the major questions, again, there's no major questions provision in the Constitution. There's no statute that mentions the major questions doctrine. The way the major questions doctrine works in practice is if an agency does something that the Supreme Court deems to be too big or too ambitious, they'll strike it down. But like, it doesn't come from anywhere. And like, the Supreme Court has never tried to like point to this is the provision of the law. Gorsuch wrote an opinion where he tried to ground it in one thing that was joined by only 2 justices. Barrett wrote an opinion where she tried to claim, and I swear I'm not making this up, that the major questions doctrine can be found within a parable involving a babysitter. So like, they aren't really even trying to pretend like they're doing law here. They're just coming up with reasons to strike law, to strike down agency actions that they don't like. And then this term, they overruled Chevron. So now, instead of the rule being that the Supreme Court's going to step in and strike down any agency action that does too much that they don't like, now the rule is that the Supreme Court can step in and strike down literally anything that a federal agency does. So, this project of dismantling the administrative state, bringing the entire executive branch to heel by putting it under the supervision and authority of the judicial branch, that is fully underway. And, it has basically been fully implemented. At this point, they just need to fill in the details of striking down the individual regs they don't like.
One of the things you said before we jumped on, which I think is a good pivot point for us, because as we're wont to do, talking about this somewhat clinically, even though we're both very passionate about it, the court is terrorizing the country and has been for the past few terms. But it's not yet clear to me whether or not the public is fully absorbed it. Congress is absorbing it a little more. We've always had great allies like Senator Whitehouse, Jamie Raskin, and many others who understand what the court is doing and exactly how it is reshaping society fundamentally. But as you write to a broader public, are you sensing that folks are more interested in what it is you're writing about, that they're really capturing how this band of 9, and really 6 of them out of the 9, as they alternate among one another, have taken on a far greater role in our democracy than anyone ever intended?
Yeah. Certainly, my traffic numbers are good. I think the polls reflect that there has been a significant backlash against this court. So like, starting from the moment Amy Coney Barrett was confirmed, the court's approval rating went from hovering around 60% fairly consistently to hovering somewhere between 30 and 40% fairly consistently. And, there are milestones where you can see, Dobbs, the decision overruling Roe v. Wade was a significant milestone. So like, I do think that the public is engaging, and I do think that they're, more so than at any point in my life, I think that people on the, left of center individuals, both within left of center institutions like the Democratic Party and just like people who hold left of center views, are more engaged with the courts as an issue than they ever have been. Now, is that going to be something that drives our politics? I don't know, because like, judicial politics is always one step removed from electoral politics. You elect this president who's going to pick people who then have to be confirmed by these other people who are elected. And like, those people have a lot of things on their plate. And like, does the fact that like, you prefer Joe Biden's judges to Donald Trump's judges overcome some other concern you might have about Joe Biden? I mean, I don't know. I mean, I just don't know whether it's going to become something that drives our politics. But if you look at the data, it's just very clear that people do not like this court. They do not trust this court. There are polls asking questions like, do you think these justices are engaged in a good faith process of applying the law, or are they just, making partisan decisions? And like, significantly more than 50% say, oh yeah, they're just making partisan decisions. And so like, the court has taken a huge hit to its prestige. Is that going to matter? Again, like, people vote on many factors, but this is one factor whose salience I think is growing in importance.
Yeah, it's a simple question. Is reform possible? Are there a set of reforms that could be enacted that in the long term would restore the court's legitimacy? I mean, it seems to me it's both that it's making bad decisions, but it's also that people are kind of fed up with our politics writ large, and it's captured by one party, but people might equally hate it if it felt captured by another party. And it's not that I'm sort of trying to return to the regal,
right,
elevated days of the Supreme Court where you really did think that they sort of floated on clouds somewhere above the rest of us. But do any of the reforms strike you as legitimately getting at the heart of what has happened to the court, which is we've appointed a group of political hacks as opposed to people who genuinely think through legal issues in a way that is nuanced and in fact quite boring, right? Things that wouldn't concern most of us. Do we have a way forward?
So I think so there's sort of two questions implicit in your question. I think one is like, what are the appropriate reforms to direct at this court? And the other is, do they have any shot at becoming law? And so like, I'll answer the second question first. Not under this Congress. You have to have, I mean, a majority of the members of the House agree with the direction that the Supreme Court is taking the nation right now. And until you have a House of Representatives where a majority of them disagree with the direction that the court is taking the United States, you're not going to pass federal legislation. So, could reform happen in the future when we have a different Congress? I guess is the question that I'll answer. And I think like there's several different ways that you could approach this. So there is, I mean, the phrase nuclear option is so overused now, but like, I think it's appropriate when you start talking about court packing. And that, I mean, I go back and forth on the question of whether we should add seats to the Supreme Court. I'm now leaning towards it because I think that the Trump v. United States decision was just so dangerous that like, it would be reckless to leave these people in charge of the country. But like, understand what you were talking about when you were talking about court packing. Like, what you were talking about is you're talking about politically delegitimizing the entire federal judiciary. If you think that that is a way to, for example, bring Roe v. Wade back, like if Congress passed a law tomorrow which adds 6 seats to the Supreme Court, and then the 6 new Biden appointees joined Sotomayor, Kagan, and Jackson in saying, okay, Roe v. Wade is back now. I don't think that the governor of Texas is going to say, "Oh, well, we lost that one. I guess abortion's legal now." I think I think that you're going to see massive resistance. And I use that phrase intentionally. I mean, you're going to see the same tactics that were used to resist Brown v. Board of Education, including the Texas National Guard surrounding abortion clinics, and it's going to be a question of, is the president of the United States willing to send troops? Can he find troops that will actually obey the order? Because I'm sure that there are people in the United States military who oppose abortion. I think we just have a realistic sense of like what can be accomplished through that solution. That is a solution to neutralize the judiciary as an institution with all of the benefits and all of the and all of the downsides that brings. But the advantage of court packing is that could be done with a simple act of Congress. The Constitution says that Congress gets to decide the shape of the Supreme Court. All that you need is a majority of both houses and the president's signature, and you can have a 15-justice court if you want. So that is the advantage of being simple. The second category of reforms is there are all of these like less aggressive ideas, term limits and like jurisdiction stripping and things like that don't make such a significant incursion on the legitimacy of the judiciary, but like because they are smaller bore reforms, they are lighter lifts. The problem you have with a lot of these, like I don't think you can do term limits without a constitutional amendment. I just think Article 3 is very clear that they serve for life,
right.
And so it's going to be very difficult to get a constitutional amendment through. I'm also not sure that term limits fixes the problem of a deeply ideological judiciary. Trump's judges were more radical than Bush's judges, who were more radical than Reagan's judges, who were more radical than Nixon's judges. So like if you enact a term limits amendment and it leads to John Roberts retiring early and being replaced by Jim Ho, you've made things worse.
Right.
And so go ahead.
No, I agree with you on those. I'm just looking at some of the questions and we should start to get to those as well. One last piece on this though. You covered I think you did the post-Scalia court pre-Gorsuch nomination when it was 4-4.
Yep.
And I've always wondered, why don't we just say they have to have unanimous opinions?
I mean, I guess you could have that. I mean, the question is like, what is the law in the absence of a unanimous opinion? Like the advantage of majority rule is that it just provides clarity of like, or like if the Fifth Circuit strikes down, rules in favor of a particular plaintiff and 6 justices say that was wrong, like, does the Fifth Circuit's decision stand?
Yeah, that's what folks have said. I don't know. I have faith that they would actually try and negotiate an outcome to reach a decision that unified the law. I mean, going back to the U.S. v. Nixon case, what I found so compelling, maybe then I'll switch to some of the audience questions, or actually what I found so disheartening about Trump v. U.S. was that the great Supreme Courts stand up to the president. Like going back to John Marshall, right? Like that's the heart of it. You stand up to the president when the president attempts to aggrandize themselves, because throughout human history, the greatest threat to liberty is the singular person who amasses all the armies and whatnot and takes over. So Nixon is another example of that, where the 8 of them across ideological bounds just sort of said, and I was reading more about how the opinion was constructed, and each person said, I'll take this piece because they couldn't agree on other pieces, but that was the agreement. You get to write the piece you get to write. It just struck me that was a high watermark of the court, as it's rightly revered to be, because they noticed that the president was being corrupt and criminal, and that was a threat. So it just feels to me like we've got to come up with some rules and procedures that force them not to just say, well, we have 6 and you have 3, and therefore we get to decide what we're going to do and ignore you.
So I guess if I had the power to amend the Constitution, I would do one of 2 things. Either I would implement some sort of merit selection process, like either something like the Missouri system or like the British system, where the way that those systems work is that you have a commission that has multiple different inputs on it. So like, I think in the Missouri system, like the Chief Justice appoints some people, the governor appoints some people, the state bar appoints some people. And the idea is that you have enough people coming from many different places that it's much harder to capture for like any one political faction to capture.
You're very Madisonian. So basically to diffuse the powers.
Yeah. And like, then like the way it works in Missouri, and many states have adopted very similar systems, is that the commission comes up with 3 names when there's a judicial vacancy that and they're just supposed to judge that based on merit, not based on ideology. And then the governor makes the final choice, but they have to choose from one of those 3 names. And it's not a perfect system. The Arizona Commission was captured for a little while and led to some pretty right-wing justices getting through that shouldn't have gotten through. But it works pretty well. Sarah Palin's appointees to the Alaska Supreme Court were surprisingly good. So good that Obama put one of them on the Ninth Circuit. And the reason why is because Alaska has a Missouri style system. So you can do something like that to take the partisanship out of it. You can also do something like the French system. So in France, if you want to be a judge, you go to judge school. It's a whole different degree than getting a law degree. And then you are in a civil service where it promotes from within, and judges are evaluating other judges based on their professional competence and not based on whether they support one political agenda or another. So I would change the way judges are selected, because I think the biggest thing that has changed since, say, the Nixon decision is that both parties have gotten extraordinarily sophisticated at making sure that they pick judges and justices who will toe their party line over and over and over again in all the cases that they care about. And one thing that I think is very surprising about American history, when you think about how much power the Supreme Court wields, is that this is actually a new phenomenon. It's fairly recent that the 2 political parties figured out how to do this. There's all sorts of historical examples. Woodrow Wilson appointed Justice McReynolds, who's considered to be one of the great monsters who served on the Supreme Court. And the reason why is because McReynolds was Wilson's attorney general, and he's an asshole. And Wilson didn't like having an asshole in his cabinet meetings, so he promoted him to the Supreme Court to get rid of him. Eisenhower famously appointed Bill Brennan, the liberal lion, who was, one of the most consequential justices of the 20th century, because he just wanted a Catholic on there because he thought it would be good. That was good politics. And it didn't even occur to him that this guy, what his politics were. So historically, presidents didn't pay much attention to the politics of their judicial appointees. And that prevented the kind of organized lockstep marching towards the outcomes preferred by a political movement or a political party that you see now. But we now live in a world, I think the shift was when Justice Kagan was appointed. Justice Kagan replaced John Paul Stevens, who was a Ford appointee. So it used to be that you couldn't look at the party of the president who picked the justice and know, pretty much everything about what they're going to say in the most important cases. This is a very recent phenomenon.
Right.
But now that it's the way that things work, if I could fix it, if there was a way that we could amend the Constitution, I think the way that you do it is that you look at how other states or other countries do their judicial selection in a way that is less easily captured by political parties.
Let's jump to some of the questions there on topics that you would expect. I'm going to take 2 of them together and maybe get your response over 2 minutes, and then jump to another one. So both are about the Trump decision and then Loper and Brightlis. We've had major revisions in the law. I'm curious, what do we do? How do we stand up to these cases? If the president is broadly considered immune, is there a way to still prosecute him for crimes? I have some ideas, you probably do too. But separately, with regard to interpreting major doctrines major pieces of legislation like Clean Water Act and Clean Air Act, what happens now that we have the judiciary has sort of swiped control of interpreting those statutes, which were intentionally written in very broad language?
Yeah. So, I think in an ideal world, first of all, you'd want Congress to be very aggressive. In an ideal world, every time the Supreme Court mangles the Clear Air Act, Congress passes a bill right away that just whatever the dissent said, that's now the law. And you do that 6 or 7 times, and potentially they get the message. The model that I often point to, this is probably such an obscure law now, but there's a law, the Civil Rights Act of 1991. And what the Civil Rights Act of 1991 was that after Reagan had had a few appointees to the Supreme Court, the court handed down a number of decisions nerfing various civil rights laws that, like, Congress, meaning there was a bipartisan consensus in Congress that those decisions were wrong. And so Congress passed this law where they just said, no, instead of that thing that you said, Supreme Court, it's now, we're doing this. Instead of that, we're doing this. Instead of that, we're doing this. And I think that was effective in getting some of the justices who joined the decisions that were overruled by Congress to slow their roll. I think that the ADA Amendments Act, which was signed by George W. Bush, it was a very effective law. I mean, the history there is that Congress passed the Americans with Disabilities Act. It was interpreted in various ways that made it very difficult to function. And that made litigating these cases very, very expensive because, defendants just had so many defenses they could raise that it was very hard to prevail. And Congress passed a law, and basically what the ADA Amendments case says, it says all those things that you've said about the Americans with Disabilities Act in the past, try again. It's not the most explicit statute in the world. It does a lot more saying no than anything else. But since then, I think the courts have interpreted the ADA in a sensible way. They got the message. So if we have a functioning Congress, I think there's a lot of things that can be done. In the absence of a functioning Congress, then I think that the path forward is to take a page from the Federalist Society playbook. So, I said earlier that the conservative legal movement is a very impressive act of political organizing. The Federalist Society is the most powerful union in the United States of America. You get all these people to engage in collective action towards their shared goals, and they have forums where they figure out what those shared goals are, and then they come up with their checklist. And what I think that liberal legal scholars who are going to be in the wilderness probably for decades should spend this time doing is figuring out what is our anti-canon. What are the cases that we would say any judge or any justice who won't vote to overrule this decision is disqualified from serving? And it can't be everything. It wasn't everything for the Federalist Society. I mean, they went after Roe. Thus far, they haven't gone after, for example, Lawrence v. Texas. Justice Kavanaugh even wrote in his Dobbs dissent, "I will not go after Lawrence v. Texas." So, even they understood you can't pick everything. But I think that Trump v. U.S. is a uniquely dangerous decision and belongs on that list. I think that Relentless and Loper Bright belong on that list. The Major Questions Doctrine belongs on that list. I think that you may remember the SB 8 case, the case saying that if so long as a state law is enforced solely by bounty hunters, then it is immune from constitutional challenge in federal courts. Oh yeah, that should be on the list. That's an existential threat to the idea that we have a constitution. Of course, that should be on the list. I think that I think that there's some cases where we need to make hard choices. I do not have a view yet on whether Dobbs should be on the list, and here's why. Mm-hmm. I think it is possible that Dobbs is such a disastrous political moment that it could shatter the conservative legal movement's coalition, that it could lead to a politics where, Trump is out there doing everything he can to distance himself from his party's historic position on abortion because he knows how unpopular it is.
Yeah.
And so if in fact it turns out to be the case that the fallout from Dobbs is that we get an electoral majority for abortion rights, that's much more powerful than a Supreme Court opinion. And so, I think we should be, thoughtful about we want to achieve certain goals. One of those goals is protecting abortion rights. It's the best way to do that through a Supreme Court decision. It's the best way to do that through something else. But like, this is the conversation that I think should be going on. You know, the advantage of being in the wilderness is that you have a lot of time to plan.
Yeah, I totally agree with that. I think Dobbs should probably be on the list just because there are segments of the country that will never permit abortion. I'm not sure that this court will allow the Congress to provide for nationwide abortion protection. It'll say the Commerce Clause doesn't reach abortion. But I think you're right. This is a time for deep thought and deep reflection. And I'm so glad that we had an hour to spend this time with you, Ian, reflecting on this particular Supreme Court, but placing it in context, looking at what the court has done in the past few terms, thinking about what it's going to do into the future. So thank you for everyone for tuning in at this time. We're always great fans of you all who decide to be fans of us in this Holding Court series. We've been seeing the audience grow month after month, and that's really exciting to me and to the team. I'll say that this is going to be my last Holding Court as president of the Alliance for Justice. We'll be transitioning to new leadership in due time, and I'm headed off to a nice, cushy foundation job. But I will miss this work profoundly, and will continue to be involved and continue to be a fan of the work of the Alliance for Justice and a fan of Ian Millhiser, who writes so eloquently, so deftly about what's taking place in our nation's highest court and our courts more generally, the impact they have on democracy. So thank you, Ian, for this time, and thank you all for tuning in.
Thanks so much.
Talk soon.